So, friends, today was a really bad day in court for Lindsey Halligan and, by extension, Pam Bondi and Donald Trump's Department of Justice. A really bad day in court in the James Comey case. So, earlier today, I was in the federal courthouse in Alexandria, Virginia, and I did two live videos, one right before the hearing and one right after the hearing, kind of briefly recapping what went on during the Comey hearing, the vindictive prosecution motion that was heard today by Judge Nachmanoff. And I want to start today's Justice Matters video by playing those two live clips, and then we'll do a roundup of how the James Comey case went from bad to so much worse today. So much worse for Donald Trump and Lindsey Halligan and Pam Bondi. Let's talk about that, because justice matters.
All right. Hey, everybody. I hope you can hear me. We are back once again at the federal courthouse in Alexandria, Virginia, to hear more legal arguments on motions to dismiss. James Comey's lawyers have filed several motions to dismiss the indictment against him. Today, we'll be hearing the arguments on his vindictive prosecution and selective prosecution motions, not to be confused with the other motions to dismiss that we've already heard argued. I was last down here when Comey's lawyers and New York Attorney General Letitia James' lawyers were arguing that Lindsey Halligan was unlawfully appointed as interim U.S. attorney. We are awaiting a decision from Judge Curry on that motion. Of course, we just had a scorched earth ruling issued by a magistrate judge in the case, talking about how Lindsey Halligan abused the grand jury process, misstated the law, likely presented evidence to the grand jury that was attorney-client privileged information such that it was incompetent. She had no business presenting it to the grand jury. So there are so many reasons that the Comey prosecution is hanging by a thread, and that one thread is fraying. So today, I'm going to head into the courtroom. I'm going to listen to the vindictive and selective prosecution arguments. And after the hearing concludes, I'll try to jump back on and give you a quick update and a blow-by-blow about what went on in the courtroom. Let me kind of show you what it looks like outside the courthouse. You know, with each successive hearing, there seems to be fewer and fewer folks from the media who are here. You know, there is still something of a media showing, but I'm not seeing much by the way of the general public coming to attend today's hearing. So, but you know what? We'll be here. We'll be here for each and every hearing until this vindictive prosecution is very likely dismissed, perhaps even with prejudice, meaning it could never be rebrought by Trump or any other administration. So I'm going to head into the courtroom and I will jump back on live at the conclusion of the hearing. The vindictive prosecution motions hearing just concluded in the James Comey case. Interestingly, we heard Lindsey Halligan speak for the first time. And even though I don't think she spoke more than, 25 or 30 words, it was a little bumpy. And it was in response to a question that the judge had that the other prosecutors, remember the fellas they brought up from the North Carolina U.S. Attorney's Office, because nobody in the Eastern District of Virginia U.S. Attorney's Office would touch this case with a 10-foot pole, probably because they all value their license to practice law. At least that's the inference I draw. They couldn't answer one of the judge's questions about how the grand jury process had played out. Now, I'm going to do a much deeper dive about this later, on Substack and on my Justice Matters YouTube channel. But interestingly, it looks like the judge may have uncovered yet another reason the indictment should be dismissed. And it had to do with how Lindsey Halligan handled the fact that the first indictment that was presented to the grand jury, let me just summarize the issue, had 3 charges, but the grand jury, no bill, voted no on one of the 3 charges. What should have happened was a new indictment should have been prepared with the 2 charges that they returned a true bill. They voted to indict. That should have then been represented to the grand jury. They should have voted on those. And if they again voted in favor of indicting, that is the indictment that should have then been returned to the judge to be officially entered in the record as the operative indictment in the case. Guess what? Lindsey Halligan didn't do that. Somebody just virtually whited out the one that they no bill that they voted no indictment on. Actually, I think they prepared a second brand new indictment with the 2 charges that the grand jury had originally voted to indict, but it was never represented to the grand jury as is required. The judge directed the parties, the prosecutors and the defense, to a case that he wants them to read on that issue and file something about what they make of that case. I mean, this case just gets worse and worse and worse for Donald Trump, Lindsey Halligan, and the Department of Justice, and better for James Comey, and by extension, better for the American people. Because this morning, before I went into this hearing, I said that the Comey prosecution seems to be hanging by a thread, and even that one thread is fraying. You know, it's kind of like Judge Nachmanoff just kind of put a pair of scissors right, on top of that one thread, and looks like he may be prepared to snip the remaining thread. But stay tuned. We should hear more about that, including by the end of the day when the parties file something based on this new case that Judge Nachmanoff brought to their attention. So stay tuned, friends. I'll be jumping back on later today, and we'll be talking more about what happened in court.
So, friends, let's do a recap. Because the Comey case started today with 3 motions to dismiss, but when it was all said and done and we walked out of the courthouse, there are now 4 reasons to dismiss the James Comey indictment. Reason number 1 is the unlawful appointment, the alleged unlawful appointment of Lindsey Halligan as U.S. attorney, such that she didn't even have the lawful authority to set foot in the grand jury in the first place. I was in court a couple of weeks ago for that argument. You may remember that it was Judge Curry, due to a conflict, who was brought up from South Carolina, federal court judge, to hear the arguments to dismiss based on Lindsey Halligan's unlawful appointment as interim U.S. attorney. And Judge Curry said she would have a ruling before Thanksgiving, so we're waiting for that. The second reason to dismiss is for Lindsey Halligan's abuse of the grand jury, her substantive abuse of the grand jury when she was in there, because as a magistrate judge just set out in his recent opinion and ruling, Lindsey Halligan, made dramatic misstatements of the law regarding James Comey's right not to have to testify now or in the future. She also, it looks like, presented inadmissible, improper, incompetent evidence to the grand jury involving some attorney-client privileged communications. So there's a motion to dismiss based on Lindsey Halligan's substantive abuse of the grand jury process. There, of course, is also the vindictive prosecution motion that was argued today before Judge Nachmanoff. He is the presiding judge over the case. And then, as you just heard in that live clip, Judge Nachmanoff also pressed Lindsey Halligan and the other prosecutors on the procedures that were used when the grand jury returned this indictment. And it looks like those procedures might be fatally defective. That's reason number 4 why the Comey indictment should be dismissed. And I'll tell you, the case is barely hanging by a thread. But friends, there's one other thing I want to touch on before we finish up, and it has to do with a declination memo, because Judge Nachmanoff pressed the prosecutors, is there a declination memo? In other words, did the prior career federal prosecutors, including Donald Trump's prior interim U.S. attorney, Eric Siebert, who refused to indict James Comey because the evidence wasn't there, did they author a declination memo setting out kind of formally, no, we can't and we won't indict this case, and here's why. If there's a declination memo, that thing damn well better be turned over to the defense, because it will be exculpatory, Brady evidence or information. And things got really sort of dicey and uncomfortable and downright ugly during today's hearing, because Judge Nachmanoff asked the attorney, the prosecutor who was doing most of the talking, a guy named Tyler Lemons, because Lindsey Halligan has barely spoken at all of these court hearings, asked the prosecutor, Tyler Lemons, is there a declination memo? And you know what we got in response, at least figuratively? Humana. We got all sorts of equivocating and misdirection and half answers. And what it looked like he suggested, and I will defer to the transcript when it is actually produced and revealed publicly. I tried to take verbatim notes as best I could, but I was writing feverishly. It sounds like he suggested the Deputy Attorney General wasn't going to let him answer that question. Like he had been told, if you're asked if there's a declination memo, don't answer it. Now you can claim, wait, that's, a deliberative process privilege or a work product privilege. It's Brady evidence. It's exculpatory, and the Constitution says it must be given to the defense. But we never got an answer to whether there was a declination memo. But Judge Nachmanoff wasn't done pressing Tyler Lemons. He said, well, is there a prosecution memo that you saw, that you reviewed? I mean, you're the lead prosecutor now. So if there are things like declination memos and prosecution memos, you certainly should have reviewed them, right? And let me just explain, friends, the difference between a declination memo and a prosecution memo. I have authored countless declination memos and prosecution memos in my time as a federal prosecutor. They're basically indistinguishable. What are they? Well, each of those two memos sets out all of the evidence, the facts that, may constitute a crime, the evidence that was presented to the grand jury, the witnesses who testified under oath before the grand jury. These memos will analyze the law as it is applied to those facts and will reach a conclusion. A declination memo reaches the conclusion that we're not going to prosecute, we can't, we shouldn't for the following reason. And a prosecution memo reaches the conclusion, yes, we're going to ask the grand jury to indict, we're going to prosecute the case. But in substance, they set out the same evidence and they apply the same law and they engage in the same analysis. So they really are almost indistinguishable from one another. But Lemons first said, I can't really say if there's a declination memo because I'm not authorized by the Deputy Attorney General. So the Deputy Attorney General told you don't answer that question if the court asks if there's a declination memo? The judge kept pushing. He said, wait a minute, I'm not asking you what's in the memo. I'm asking you for a yes or no answer. Was there a declination memo drafted? We never did get an answer in court to that question. We got a lot of humana. But the judge was not satisfied, and the judge went on to ask, okay, was there a draft prosecution memo in the case? Again, a lot like, but strictly speaking, different from a declination memo. And here is how Lemons answered that question. Is there a prosecution memo? He said, quote, my understanding is a draft prosecution memo had been prepared. I think that's a verbatim quote, but I'll defer to the transcript when it's available. Let me use those words again. Quote, my understanding is a draft prosecution memo had been prepared. Oh, that was his understanding. The judge followed up. Did you review it? And Lemons then sheepishly said, yes. Okay, I know that it may not strictly speaking be a flat out lie when a judge asks you, is there a prosecution memo? And the best you can come up with is the equivocal, my understanding is a draft prosecution memo had been prepared, when your answer should have been yes, Your Honor, because I saw it, I reviewed it. This is the flavor of what we're getting from these prosecutors who were brought up from North Carolina, because apparently nobody in the Eastern District of Virginia U.S. Attorney's Office was willing to step in to this vindictive prosecution and try to prop it up for Donald Trump and Pam Bondi and Lindsey Halligan. And there's so much more I could talk about. I have 10 pages of notes, but I want to leave it at that because I have a feeling there will be more revelations in the coming days, maybe even from the Department of Justice, given some of these equivocations that we heard in court today. And as I say, we're still waiting for the ruling from Judge Curry. We're going to get a ruling in fairly short order, I suspect, from Judge Nachmanoff. And I'll tell you, friends, you've heard me say before, I'm not a betting man. I'm not a high roller. $1 is my betting limit. I will put the full buck on the Comey case being dismissed, probably for multiple reasons. Because justice matters. As always, friends, please stay safe. Please stay tuned. And I look forward to talking with y'all again tomorrow.